And then we have no disclosures for this event. Neither the speaker or any of the planners for the forums have any financial disclosures to mitigate. And then if you are a UW learner, you need to text for your attendance if you are claiming any CME credits. So that is the initial number that you need to text. You're just going to text them your email address that's affiliated with your CME account. And then you should get a confirmation text, and then you'll text the activity code, which is 1126. And if you've done it correctly, you'll get that little confirmation message at the bottom in purple. And if you don't, feel free to send me a chat or an email after the forum, and we'll get you, make sure that your attendance is recorded. If you are not a UW learner, then we have an evaluation survey that will pop up at the end of this. And I just need you to fill that out. And then your registration and your participation will be recorded, and we'll submit that at the end of our series for your credit. It's 1 credit per session. So if you attend all 10, you'll get 10 CME credits at the end of the program. And again, we are every month, second Wednesday of every month from 12 to 1 on Zoom. And then I have just an announcement. Our Advanced Training in Healthcare Ethics online certificate program starts later this month. We are still accepting applications. We are extending the deadline to September 20th. If you have any interest in becoming an ethics consultant, being on an ethics committee, or just want to learn more about healthcare ethics to improve patient care, I definitely recommend checking out this program. It's a distance learning format, super convenient for working professionals, and it's really incredible. A lot of you who have attended summer seminar already got a little taste of what it might be like. And if you have any questions, feel free to email us at bhcontinuinged@uw.edu or send me a message. There's a question in the chat about repeating. I'm guessing about CME credits. Catherine? Oh, for the text number, yes. Let me go back to one. And then I will pop it in the chat so you all have it as well. So it's 833-394-7078, and you have 1 hour after the event to text this in. All right, and then some future dates coming up. We have our next forum on October 8th. And again, we're every Wednesday, every second Wednesday of the month. We have them every month, except in the summer from 12 to 1. And the department also has our bioethics grand rounds once a quarter. So this is put on by the department. And our upcoming one for this quarter is Tuesday, November 19th, also from 12 to 1. We have a great speaker, Robert Klitzman, and he will be speaking. The title of his presentation will be Doctor, Will You Pray For Me? Medicine, Chaplains, and Healing the Whole Person. So this sounds amazing. If you're able to, please join us. And without further ado, I'd like to introduce our speaker, Dr. Patricia Kuszler. She used to be an emergency room physician. Is that correct, Pat? And she joined the faculty of the School of Law at the University of Washington in 1994. She's a professor of law. In addition to her law faculty appointment, she's an adjunct professor in the School of Medicine, Department of Bioethics and Humanities, the School of Public Health, and core faculty at the Institute for Public Health Genetics. Her teachings and research interests include the impact of law and regulation on healthcare delivery, healthcare finance, research standards and misconduct, health and human rights, disability law, public health law in the age of bioterrorism, global and comparative health law, and the legal, ethical, and policy issues presented by genetic information in the biotech industry, which is a mouthful. She's incredible, and I'm so excited for you all to be learning from her today. So without further ado, here's Pat.
Well, thank you so much for the lovely introduction, and thank you all for showing up today at this ethics forum. This is a very interesting topic for us this particular time of the year, particularly before the election, and it is extremely timely given recent events in the law. This is truly the cutting edge area in law right now, which is in the beginning of life era. Go ahead and change the slide. I'm having Carrie change the slides because I did this very same talk for the summer ethics seminar, and I used my laptop, and whenever I touched it, it went forward 4 slides. So I decided to go for the having someone else do it. Today, I'm going to briefly cover sort of your civics class from when you were in high school on what's law, why does it matter, what's the difference between constitutional law and statutory law, the levels of the court system, and how we essentially should care about what's been happening in our legal world over the last 2 years. My talk today will focus on the beginning of life. These are the areas of prior to pregnancy, pregnancy and abortion, and how the law has changed our in this area tremendously over the last few years. Next slide, please. So to take you back, I'll talk a little bit about the sources of law and the hierarchy of law, and we'll move right on next to the next slide. You probably all remember from your civics class, we have 3 branches of medicine, 3 branches of government: the legislative, the executive, and the judicial branch. And what I'll be talking about today is the difference between legislative action and judicial action, and the difference between constitutional law and legislative law. Next slide. Essentially, we have a system of dual sovereignty, this federalism idea. This is the idea that we have a federal government and state governments. And to put not too fine a point on it, what it comes down to is that federal power under the Constitution is very limited. Next slide, please. And essentially, the Supremacy Clause and the doctrine of preemption apply in certain areas where the federal arena is implicated, or where there's arguably both a federal and state role in creating law. Much of the federal power derives from the power to tax, spend, and regulate interstate commerce. And essentially, even though this sounds like a very few areas, these are great, big, broad areas and implicate a great deal of legislative power on the part of the federal government. Next slide, please. Essentially, what we have is certain powers that are delegated to the national government, and you sort of see them here circled in blue. And then you have certain powers that are reserved to the states. What that means is that the state power is preeminent. And essentially, they have power over this rather than the federal government. And you see in the middle overlapping area in this slide that there's a lot of areas where you have concurrent jurisdiction. This means that either the federal government or the state government can legislate in this area. And notably, the area of public welfare is probably one of the areas that we'd be thinking about. Okay, next slide. So everything that's not delegated to the federal government in the Constitution pretty much devolves to the states. And states are generally organized in the same way as the federal government, with 3 branches of government: legislative, executive, and judicial. And the idea is that people are subject to both federal and state law simultaneously. So, for example, those of us in Washington are subject to Washington state law and also federal laws in those arenas where there is concurrent jurisdiction. And the goal is cooperative federalisms. And this doesn't always work perfectly, because sometimes states object to the federal government meddling in what they see as local and sovereign rights. And so often there's a little bit of a standoff between the federal government and the state government. And there may be areas where there's a direct conflict. A good example of that for us today, which we're not going to cover, is the issue of marijuana. Most of you are aware that many states have legalized marijuana for medicinal use or recreational use, or both, but the federal government still maintains that it is an illegal substance. Next slide. So essentially, we have sort of 50 states, a couple of territories, who all have sort of their independent legal setup, legal systems that may or may not agree. And we all know that the local authorities, the state authorities, vary tremendously from state to state. Next slide. We also have a series of several different levels of court systems. At the local level and the lower level, we have our district courts. And these are the courts of first impression, where the court will hear cases, decide the cases on the facts, and make a determination. And then frequently, in some, at least somewhat frequently, one or the other of the litigants will be disappointed. And they may decide to appeal the decision. And this is sort of the intermediate level. Essentially, this will go to the courts of appeals. And we have 12 regional courts, including the DC Circuit. And essentially, what these courts are is no original jurisdiction. They will not decide the facts of the case again. What they will look at is how the law is applied to those facts. So the time for putting facts up in the courtroom is over. The time now is to determine whether those facts merit a relook in terms of the law. And then last but not least, we have the Supreme Court, the highest court in the federal system. 9 justices, typically appeals jurisdiction through the certiorari process, which typically means that the only time a case goes to the Supreme Court is when two different courts of appeal, 2 different geographic area circuits have what's called a circuit split, where one has decided a case one way and another has decided the case the other way. And it will be up to the Supreme Court then to make the final decision. They also do have limited original jurisdiction over some cases. So we would see that in cases that are profound federal questions. Certainly, I would say one of those areas that we might see that and could have seen that and sort of have seen that is in the immunity decision that recently came down. Okay, next slide. As I mentioned, we have 3 levels of courts. In the federal level, we have the same 3 levels at the state level. We have our trial courts, our appeals courts, and our Supreme Courts, pretty much in every state. And as I said, federal questions will travel through the federal side, state questions will travel through the state side. Sometimes a question that could have both federal and state implications will cross over. So we will talk a little bit about that. Once a case goes to a court, one of the questions is going to be, what is the standard of review? And certain kinds of cases, most cases, are subjected to what's called rational review. The court will look at the case and look at whether or not the regulation, particularly if it's a government regulation that someone is disputing, is there a legitimate reason for this regulation to be there? Can we justify the government's intervention? So, for example, this falls into areas that are things like ordinary rights, like land rights, disputes between neighbors, boundary rights, typical state laws that have to do with economic issues. So, for example, if I wanted to build a Space Needle in my backyard, in my house in Seattle, and the government said, no, you can't do that. We have a regulation that says you can't be over 40 feet high in a residential area. I would say, I am deeply enamored of the Space Needle, and I wish to do this. I might appeal up. It would be given rational review. I would lose that case. And then as you move up into standards of review, some things are given very careful scrutiny. This is called strict scrutiny, and it applies to areas of fundamental rights, cases involving things that are intimate, personal. And this leads us into the arena of constitutional rights. And both our federal and our state constitution give us, as individual, certain kinds of individual rights. Typically, these would be things that are intimate, personal, marriage, parenthood, how we make decisions about life and death, who can enter our homes, and what security we have in our homes, intimate, personal arenas. And typically, Those are things that speak to sort of rights that are laid out in our constitutions, um, uh, like the right to be free from soldiers being quartered in your homes, freedom of religion. These sorts of things are all going to be given what's called strict scrutiny, where intimate personal decisions are given very careful review if they're touched upon by a law in a given state or the federal government. So this leads into the arena of constitutional rights. And so it matters what's in those lists of constitutional rights. Um, and so a constitutional right that is being impinged on by a state or federal law will get strict scrutiny when that case goes up to the court. We have a variety of intermediate areas. Intermediate review is sort of in between. It might it's got more strict scrutiny type, more intimate personal implications than perhaps property law. The one that's most common is gender discrimination and quasi-suspect classes, which is like national origin. So you can sort of see we have these different levels of review. And as we move into talk about the beginning of life, we'll be talking a little bit about termination of pregnancy and abortion and childbirth. And so, as you can probably figure out from this slide, generally speaking, these sorts of intimate personal decisions would be given strict scrutiny if the state or the federal government created law that implicated these. Okay, next slide. So these would be sorts of issues that would be involved in life, liberty, or property. This includes the right not to be restrained, persons, home, family, marriage, children, raising children, religion, intimate personal rights and realm. Generally, an area that we think of as being very sacred, very protected, guaranteed by the Constitution, and indeed given a great deal of deference by any court, whether it's from a state constitution or a federal constitution. These are sort of bedrock principles in our federal constitution and are granted to us by our founders. Next slide. So we often want to ask, what kind of right is it? Is it fundamental? Is it something that is spoken of in the state or the federal constitution directly? Like the right of liberty, like the freedom to travel, like the sanctity of the home and the integrity of the home. Is it some kind of, can it be construed in the penumbra of one of these fundamental rights? Or is it an ordinary right, like something that implicates our property, something that has to do with money, something that has to do with business, which is typically something that would be accorded only rational review, not the higher level of care and protection that is granted to intimate personal rights. Now, this word penumbra is kind of important because for many years, as we looked at our Supreme Court, one of the questions was, what kind of review are they going to give a particular individual right as it comes in front of the court? And some of you will probably remember back to the times of lore when we have justices like William O. Douglas and Harry Blackmun, where you had the idea that each of our fundamental rights that's in the Constitution actually has a penumbra, an ethos around it that might implicate other things that might be addressed in the law. Like, for example, privacy, which, by the way, is not mentioned in the federal Constitution, but is given to us in several of our state constitutions, including ours here in Washington. So this idea that a fundamental right might be obliquely referred to in the Constitution, but still be a right, is something that was present in our constitutional history through most of the 20th century, and currently, I would say, is not recognized in our more doctrinal approach to the Constitution. Next slide. This is just a slide that deals with the 14th Amendment, which is often called the Equal Protection Amendment, passed in 1866, ratified in 1868, sorry. And it lays out a variety of things that deal with racial and equal protection issues, which are also generally accorded a higher level of scrutiny by the court if it implicates a minority racial group. Next slide. So the first question when we look at something that is going to the court is we think, is equal protection an issue? Is it a suspect class, a racial class? Is it something like a quasi-suspect class, like gender or national origin? Or is it just a non-suspect class? It doesn't affect a type of person differently than another type of person on the basis of race or national origin or gender. Many statutes address equal protection and provide even more nuance. And then the question is always, what level of review should be used? And obviously, sort of intimate personal things, we would expect a high level of scrutiny, strict scrutiny. And if it's something that is not so personal, not so intimate, is more economic, it would get rational review. Okay, next slide. Essentially, as we take a look at each of these laws, the constitutional right to equal protection of the law, or whether or not it's a constitutional right, the question is, what kind of impact does a law have on these rights? Is it direct, indirect, or disparate? Go ahead, next slide. So I'm going to focus my entire presentation today on the reproduction and termination of pregnancy. This is a very hot area of the law, particularly in our upcoming election, and it is quite nuanced, given some recent cases. When I give this presentation to the summer seminar, we move all the way to the end of life. Today, we will not be doing that, so there'll be plenty of time for questions. Next slide, please. Okay, so let's go back in time. Reproduction and the termination of pregnancy. As we go back in time, we know that these issues are not new. These are issues that have pervaded our societies all the way back into the BC era. Papyrus scrolls dating back to the 1850 BC talk about methods of preventing pregnancy. And indeed, this was a fundamental issue for populations many, many thousands of years ago. In the early 1800s, the average woman in the US will have given birth to 8 children. And obviously, this was a dangerous enterprise. We did not have antibiotics. We did not have the technologies we have now. And consequently, of course, death from childbirth was not uncommon. There was also a growing concern about the obscenity issues. In 1875, we have the Comstock Act, which outlawed contraceptives. And essentially, this law, which was seen to be an anti-obscenity law, came about as a result of a very sort of conservative right-wing group of the Congress, and this law was passed. And essentially, this essentially outlawed contraceptives, that outlawed abortions and termination of pregnancies, and obviously also attached to documents that were viewed as obscene. Despite this, by the time we got into the late 1800s, the average woman had given birth to 3 rather than 8 children. So obviously, there was some growing knowledge of how to limit pregnancies. In the late 1950s, the first birth control pills were created. And by the early 60s, they were available. And they changed the role of women in society. And essentially, it was during those years that we began to see the so-called feminism movement take root. In 1965, we had the Griswold v. Connecticut case. And this was a case that went to the Supreme Court, and it involved a piece of statute in Connecticut that held that providing access to contraceptives was against the law. And indeed, Griswold v. Connecticut involved a married couple who had sought contraceptive advice and devices from a Planned Parenthood in Connecticut. Not a pretty sophisticated community. This is in New Haven, Connecticut, Yale University. And essentially, the question was, should this violation of the Comstock Act be overruled on the basis that the intimate decision-making of a couple in their bedroom should be viewed as a constitutional right, not susceptible to a law like the Comstock Act. And indeed, the court, in a opinion written by Justice William O. Douglas, said that essentially what happens in the bedroom between between a married couple is in a sphere of personal activity and liberty that should not be susceptible to state laws or federal laws like the Comstock Act. That this is intimate, personal, something that is a constitutional right, and that essentially any law touching this activity should be subjected to strict scrutiny because it is intimate, personal, and something that should fall under the life, liberty, and issues of the Constitution. Notably, this is where we saw the first use of the word penumbra. Justice Douglas said, each of our constitutional rights has an arena around it that implicates activities today, even though the Constitution was written back in the 18th century. This was seen as the beginning of the idea of developing the area of strict scrutiny with respect to intimate and personal activity. A few years later, we saw Roe v. Wade in 1973 that dealt with termination of pregnancy in an opinion written by Justice Blackmun. He used Griswold v. Connecticut as a precedent and talked about the fact that a woman's decision to continue or maintain a pregnancy was in the similar sphere of personal, intimate activity that should be constitutionally recognized and not be subjected to state intervention or law. It was a very elegant opinion that was based on the scientific data at the time that split pregnancy into 3 trimesters. We often saw this picked up by the medical profession in terms of three trimesters. In the first trimesters, Justice Blackmun argued that there should be little, if any, state intervention in women and doctors' decision-making. In the second trimester, there was more chance that you had a life in being in the second trimester, and the state might have some justification for creating regulations that would limit what doctors and patients could do at this stage of pregnancy. And obviously, in the third trimester, the argument was that the fetus might be capable of life outside the womb and should be accorded some recognition and protection by the state. So essentially, that took us through the early abortion cases. This was quickly countered by the Hyde Amendment in 1978, which said that the federal government would not pay for any kind of these sorts of procedures through Medicare or Medicaid. Okay, and of course, none for the military, because that's also federally funded. So we have these things in tension. The Hyde Amendment created by statute, federal statute, that says the federal government will not pay for the services related to abortion or pregnancy, or birth control for that matter. And the Roe v. Wade case, which is clarifying a constitutional right to bodily integrity, particularly in the first trimester. Next slide, please. And of course, when we think about our standards of review, what we see is contraception and first trimester abortion up there in strict scrutiny. It was never actually clear what kind of review would be guaranteed to other kinds of abortions, but we will save that for another lecture. Next slide. The court changes over time. And in the last iteration of major changes on the court, we saw several things change. As we saw Justice Brennan retire, replaced by Justice Souter, Justice Marshall retires and is replaced by Justice Thomas. The nature of the court changes. By the time the case of Planned Parenthood v. Casey arrives in 1992, the issue of how much state regulation should be accorded to, should be allowed for termination of pregnancy situations comes to the court once again. And here, Justice O'Connor authors the opinion. It is a 5-4 decision. I might not have mentioned, but the Griswold decision was a 7-2. So essentially here, what is at issue is a law in Pennsylvania which had a variety of requirements placed on anyone seeking an abortion. And essentially, Justice O'Connor upheld the right to abortion and said that pieces of statute that affected reproductive rights should be subjected to a standard of undue burden rather than strict scrutiny. What that means is that they're not given as quite as much protection under our Constitution as we saw contraception have. It's a new standard. She had talked about undue burden in the context of end of life in an earlier decision. But essentially, this puts a new standard on the slide, so to speak. More importantly, she talked about reproductive rights being couched in liberty rather than privacy. And what this signals is that the court is moving to a more constructionist approach, where they're looking at the Constitution in its literal frame, the actual words rather than any kind of penumbral impact. So, for example, the earlier cases involving birth control and the Roe case dealt with the idea that this fell into the privacy sphere, which in turn was sort of under the penumbra of liberty. So you can sort of see the change in the court, change in the approach. Okay, go ahead and change the slide. And essentially, when we take a look at what level of scrutiny we get, we see now that contraception remains high up there in getting strict scrutiny, but first trimester abortion has now fallen down the list a little bit to first trimester abortion and is not as heavily protected constitutionally as it had been in the past. Next slide. Now, there's a changing venue for abortion. In 1973, hospitals made up 80% of the constitution of the country's abortion facilities. By 1981, however, 18 years later, 90% of the abortions in the US were performed at clinics. And today, about 2/3 of termination of pregnancies are medication abortions in early pregnancy, and only a tiny single digit affect pregnancy after the first trimester. Meanwhile, states have taken other approaches, particularly our more conservative states, to regulate abortion providers. These are what's called as trap laws that require more regulations to apply to clinics that perform surgical abortion of any type. Some of them, many apply to physicians' offices. Sometimes they apply to sites where medication abortion is provided, even if there's no surgical intervention. 17 states have licensure standards comparable to surgery centers, performing much more complex surgeries like hip replacements, knee replacements, and even cardiac bypass surgery. 18 states have series of requirements largely unrelated to patient care, and 12 states place unnecessary requirements on the clinicians providing those services, like they have to have privileges at a hospital within an X number of miles. So we had these laws coming out of various state states, and that are frequently challenged and going to the various courts. Next slide, please. We now have yet another situation with the changing court in reproductive rights. Justice Gorsuch replaces Justice Scalia. Justice Kavanaugh replaces Justice Kennedy. At this point, the court has a conservative majority. And then in 2020, Justice Amy Coney Barrett replaces Ruth Ginsburg, who died in September of that year, just before the election. And now the court has a supermajority of conservative justices. Next slide. Shortly thereafter, of course, we began to see the cases that would form the Dobbs case make their way through the court system. In Texas, the Texas law outlawed abortion once there is cardiac activity. This is defined as any electrical function cited, whether or not it's in the site of a visual heart or not. There's no exceptions for rape or incest, very limited exemptions for health and life of the mother. Curiously, this law also deputized private citizens to sue anybody who performs an abortion or aids or abets in a procedure, including people who have no connection to the patient or the clinic, and they can sue and recover legal fees as well as a $10,000 bonus if they win. This is sometimes referred to as essentially a law that allows for people to target people who patients who seek termination of pregnancy, whether or not they're connected to the patient, a bounty hunter, so to speak. In Mississippi, a similar law, not quite as draconian, makes most abortions illegal after 15 weeks of pregnancy, about 2 months earlier than Roe, and later decisions allow. It essentially, I think it's fairly well regarded, well known that essentially time of even remotely having a viable fetus is about 22, 23 weeks, depending on the center. The Fifth Circuit Court of Appeals, where Mississippi and and Texas are, is one of the most conservative in the country. And essentially, the Fifth Circuit found it conflicted with Roe v. Wade and subsequent abortion decisions. About 93% of the abortions in 2018 were performed before 14 weeks gestation, and 75% were before 10 weeks. Go ahead, next slide. This led to our Dobbs case, which was heard by the court in 2022. It consolidated the Texas and Mississippi cases, and the court reevaluated the right to abortion. In a 6-3 decision authored by Justice Alito, the court overturned Roe v. Wade, finding no constitutional right to reproductive decision-making, and he grounded this in history. Essentially, this takes away all constitutional underpinning for abortion and contraception, for that matter. And particularly note, Thomas's dissent says that contraception, same-sex marriage, other rights grounded in liberty are not grounded in historical rights. This is a signal that these are the cases that they will be seeking to have come up to the court for reevaluation. What does this mean for us? Next slide, please. Remember all those trap laws? Those all become more viable. There are also a slew of what's called trigger laws. These are state laws in states that would take effect if Roe were overturned. So 21 states have these laws. They've moved to restrict abortion earlier in pregnancy, and 17 states have barred it at 6 weeks or earlier. Mind you now that, of course, most women do not know they're pregnant at 6 weeks. Many laws have required parental consent for birth control and reproductive services. 50 bills have been introduced across 28 states. It's actually more than that since I wrote this slide, that would interfere with the ability of students to receive comprehensive sex education. There's a mismatch of states passing or permitting laws giving fertilized embryo personhood status. And nearly all allied are nearly half of all states now restrict gender affirming care for people younger than 18. Next slide. Meanwhile, the medical abortion scene, mifepristone, also known as RU486, blocks progesterone and essentially prevents or limits an existing pregnancy from progressing. Misoprostol, taken 24 hours or 48 hours after mifepristone, works to empty the uterus. It's a medication. Abortion is safe, highly effective, particularly if the pills are administered at 9 weeks gestation or earlier. And essentially, the success rate is 99.6%, and there's a 0.4% risk of complications, and even tiny of any kind of a mortality rate. They must be prescribed by a provider. 33 states require a physician provider, but an increasing number of states allow pharmacists or nurse practitioners to prescribe. In 2023, 63% of US abortions were medication abortions. In other words, not surgical. Next slide, please. Then we have, just this last year, the FDA, the Alliance for Hippocratic Medicine case. The plaintiffs argue that the FDA's approval for mifepristone, one of the drugs used in medical abortion, should be withdrawn. Now, meanwhile, this drug has been on the market for over 20 years. It has a very low complication rate and is deemed quite safe. Essentially, in a unanimous ruling for the FDA, the court held that the Alliance for Hippocratic Medicine did not have standing to bring the case, since none of the doctors in this case were engaged in obstetrical or abortion care. This ruling, while preserving access to mifepristone, does not foreclose future attempts by other plaintiffs. And this implicated a growing movement to repudiate science and overturn what is called the Chevron doctrine. Now, why should we care, you say? Because essentially, in this case, what we have is litigants, the Alliance for Hippocratic Medicine, essentially saying that the FDA cannot be trusted and that the FDA's review of a medication for safety is irrelevant or is not protected from being reversed by a court. And so why should we care? Well, we should care because right on the heels of this case came another case. Next slide, please. And that is Loper Bright Enterprises et al. V. Raimondo. This is a case that does not involve mifepristone, but has profound impacts on mifepristone and literally science in general and how it's reviewed by the courts. This case overturned the Chevron doctrine. The Chevron doctrine had long been recognized as a cornerstone of constitutional law and Supreme Court practice. Essentially, the Administrative Procedure Act requires courts to exercise judgment on whether an agency has acted within its statutory authority. And essentially, this course says that the courts can't defer to an agency interpretation simply because the statute is ambiguous and overrules Chevron. Which this means is that when mifepristone comes back to the court, which it will, or the Supreme Court, which it will, the court need not accept the FDA interpretation of the safety of mifepristone. Similarly, as we take Loper Bright Enterprises even further, this applies to any agency that does scientific review. For example, environmental protection agencies, whether or not something is an environmental threat, whether or not occupational health issues. This requires a de novo scientific review, not by experts, but by a court. So these courts probably will not have the scientific expertise to support any holding they come to. This is a great big deal in administrative law. It's like it's a huge case, and it implicates everything underneath it, and particularly it certainly implicates issues like mifepristone. Next slide. Meanwhile, on another front in the termination of pregnancy, we have the Idaho case. In Idaho, abortion is completely banned with very limited exceptions. There's a 24-hour waiting period. There's no Medicaid coverage. Private health insurance of abortion is banned except in very limited circumstances. There's parental consent. Only physicians can provide abortions, and not other qualified healthcare professionals. Next slide.
We have about 8 minutes left, Pat.
Oh, geez, I gotta go faster. Most of you are familiar with EMTALA, the Emergency Medical Treatment and Active Labor Act. When a patient comes in with an emergency condition or a pregnancy-related problem, the requirement is that the emergency department provide appropriate treatment for this, and indeed not transfer the patient simply to get rid of a problem. We know that in most obstetric injuries, problems, hemorrhage, sepsis, cardiovascular shock, death, all are emergency conditions. So clearly EMTALA and Idaho are in conflict. Next slide. So essentially, the emergency docs and the Biden administration argue that EMTALA requires healthcare providers to provide the necessary treatment, regardless of the state's abortion restrictions. Next slide. And essentially, the Supreme Court bounced this back to the Ninth Circuit. We're waiting for the Ninth Circuit to decide on this. But in the process, the Supreme Court lifted the injunction that protected doctors from prosecution in the state. So we're now faced with a situation where we expect on appeal, when it goes back to the Ninth Circuit, that essentially they will enjoin and continue the injunction on application of the Idaho law. Meanwhile, the Fifth Circuit Court of Appeals has determined that doctors in Texas were not required to perform emergency abortion care under EMTALA. This constitutes a circuit split. It will go to the court likely next session. Next slide. And of course, we have this case. As I said, this case will come back to the court with the split between the Fifth and the Ninth Circuit, two of the most dynamic and important circuits in the sphere of Supreme Court law. Next slide. So these are cutting edge cases. They demonstrate an ongoing focus on law and ethics at the beginning of life. It's the most dynamic and cutting edge issue we've seen in the last 55 years. It's cut an entire chapter of law out of our constitutional fabric. We are now experiencing the aftermath. Many states are busily trying to regulate healthcare out of medicine and into political play. The other half are seeking to stabilize a complex medical and legal problem. Women and their families are at the center of this medical tug of war, and doctors are equally impacted and are going to need to step up to the plate for the patients. Next slide. And this is the last slide. And essentially, our abortion cases have grave implications for everything from gay rights, in same-sex marriage, privacy rights, sanctity of the home, any kind of area of what we think of as privacy and personal protections provided by the Constitution. And we see a willingness for the court to alter constitutional protections we thought were secure. We see a willingness of the court to eviscerate our expert agencies and put those decisions in the hands of courts that do not have the expertise. It is a perilous time. I know we're very close to the end. I'm willing to stick around, and I'm quite willing to take any questions that you have. Any questions? There must be some. It's such a dynamic area.
If anyone wants to come off of mute and ask a question, they should be able to now.
Is there anything that makes you feel hopeful? Yes, there is. As we look at our upcoming election, we now have 10 states that have the right to abortion and family planning on their election slates, and all of those are state constitutional provisions, essentially seeking to put in a constitutional provision to protect abortion, reproductive rights, rights of women into the state constitutions, even if they're not in the federal constitutions. So far, a couple of states have gone into this area, and those constitutional amendments have passed. At the state level, a constitutional amendment is protective, just as a federal constitutional amendment would be, albeit only in that state. We have 10 states that have constitutional amendments pending that we will hear about on November 6th, as we have the elections. You should keep an eye on all of those because we expect that they will have an effect in those 10 states. And the downside of that is that none of those states are probably the states where the right to termination of pregnancy has been particularly terminated down to where women cannot get a termination of pregnancy even before after 6 weeks. So the very more limited rights states are not those states that have constitutional amendments pending, but 10 states do, and there's a few states that put in constitutional amendments last year. Here in Washington, we have a statutory protection that is quite firm, which deals with in terms of pre-viability and viability. I suspect in the future we'll see a constitutional amendment here in Washington to formalize that constitutional right for us. Other questions?
I just had a question about how are they even able to change the Constitution, like reversing Roe versus Wade? I didn't understand that because I thought when something went to the Supreme Court and it was decided, that was the decision.
Well, then generally that is true. Generally, once something has gone to the Supreme Court and they have made a decision on that particular right, it's very unusual. In fact, it's completely unusual. I believe abortion is one of the only times this has ever been done. It can be reversed, but it has to be reversed at the Supreme Court level, and indeed it was. So it is quite unusual. In fact, I believe in our entire constitutional history, the only time we've had any kind of a right rescinded is the abortion context. So it's very unusual. It's quite radical. Donna has a question that says, does the very definition of about viability affect? I'm sorry, I missed let me just take a look at your question again. Does the very definition about viability affect how birth mortality is reported across states, other countries? I don't know the answer to that question. I would say that I don't know the question of how viability plays into the statutes on birth mortality in other countries or across states. I'm not quite sure how that's recorded. If it's not a life in being born alive, I would say it doesn't affect it, but I don't know about that for sure. Okay, next question. Okay, well, if any of you are interested, this term I'm teaching a course on the beginning of life up at the law school in the fall term. And I'll send over the link, the time for that to Carrie, and you're more than welcome to sit in anytime you want. And it is, I believe it's on Wednesdays from 1:30 to 3:30. Obviously, it's going to be very focused on what's happening in our upcoming election. but it will be sort of a from fertilization to birth kind of course, and it will encapsulate everything to do with birth control, termination of pregnancy, and also issues of maternal fetal conflict.
There is one more
Okay.
quick question,
Yes.
Pat.
Okay.
Are there any other specific court cases to keep an eye on in regards to reproductive rights and other civil liberties?
Oh, there's many. Obviously, the 10 states that have amendments going. Obviously, you want to keep an eye on the Idaho case. That's going to go back to the Supreme Court probably this upcoming term. Similarly, we're going to see the mifepristone case go back to the Supreme Court, if not this term, next term. So those are the ones that come to mind immediately. I suspect others will pop up in the aftermath of the election. So in some cases, if we have, depending on what the outcome of the election is going to determine whether or not we have other cases sort of come out of the woodwork. Obviously, one of the problems with a situation like we have now, I mentioned most of those states with amendments pending are not in the deep South where we have very draconian laws. But what will happen is we will become more of a sort of having one set of states that have a demonstrated right to termination of pregnancy, albeit with some limitations. And then we'll have another states where it's vigorously prohibited. And it sets sort of up a dichotomy in our nation where we have a different set of fundamental rights in one state as versus another. And that's a dangerous thing for other areas of our law and our society beyond just abortion.
All right. I'm sorry, everyone. We are out of time right now. Pat, thank you so much for this
Quite
wonderful
welcome.
presentation.
It's a big area and it's a hot area. Everybody pay attention to what's going on in the world here.
All right.
And thank you for coming.
Of course. I will send out that information about your upcoming course, and everyone have a great day. Thank you so much.